Dear students, I, Sunita Tripathi, am an assistant professor at the General Global Law School, where I teach courses related to intellectual property law. Today we are going to discuss the module on the subject matter requirement in copyright law. The aim of this module is to familiarize you with what constitutes copyrightable subject matter as well as what is excluded from copyright protection. At the end of the course, you will be able to examine the fundamental concepts pertaining to copyrightable subject matter as well as identify the contradictions and tensions between protection and creation of copyrightable subject matter. Finally, it is expected that you will be able to conduct case law analysis and identify and understand legal principles which support what constitutes a valid copyright subject matter. Let's begin with the fundamentals firstly. The term of protection afforded to any copyrightable subject matter is not an infinite number of years. Copyright is not a perpetual right. It exists for a specific term, and after the expiry of such term, the work which is actually the copyrightable subject matter falls back into public domain. And this work is essentially protected in India for the term of 60 years from the death of the author. And for photographs, cinematographic films and sound recordings, it's 60 years from the beginning of the calendar year to the next following year in which it was published or released. So essentially, it is a limited monopoly right which is exclusively granted to the proprietor of this subject matter. So the prerequisites for qualifying the subject matter are essentially threefold, and Section 13A of the Indian Copyright Law provides such prerequisite. It describes that the Indian Copyright Act provides only original literary, dramatic, musical and artistic work the affordability and protection of copyright. Thus, not all works enjoy copyright protection. Any literary, dramatic, musical or artistic work has to be A, original, and B, needs to be fixed or expressed in a tangible medium to be afforded any protection. In that sense, let's understand what is the basic concept of originality. Originality as such need not be attributed to becoming a novel idea. It is essentially an expression of thought or work which originates from the author. So originality goes back to the source of where that expression came from, that is the author. In the famous case of the University of London Press versus University Tutorial Press, the commercial law dispute matter, it was observed that original does not mean an inventive or novel thought. The work must not be copied from another work and it should originate from the author himself. And so the court held that a work which is expressed in print or writing, irrespective of whether the quality or style is high, is supposed to be original work. The mathematics examination paper in the said case was considered to be original literary work in that. Finally, there are other two cases which are worth describing right now. In Walter versus Lane, the court observed that the author must exercise his own labor and skill. The facts involved a book which was published based on articles in the Times which were verbatim of the speech made by the person. The court relied upon the doctrine of sweat of the brow, which is followed in the United Kingdom, to hold that the book was original work of authorship. Another case worth remembering is Ladbroke versus Hill, where the football fixtures were held to be original literary work. Originality meant that work must originate from author and be result of skill, labor and judgment. Sufficient skill is required, not extra or modicum of creativity at all. Coming back to the Indian premise, Section 13 of the Indian Copyright Law, which describes the work as copyrightable subject matter, as I said, expects the author to produce original literary, dramatic, musical and artistic work, A. B. Cinematographic films as well as sound records. So it shall exclusively mention what is copyrightable subject matter as well as what is excluded from such protection. Section 40 and 41 discuss foreign works. The central government is empowered to extend Indian copyright protection to foreign works via publication in the official gazette. Countries which are listed in the International Copyright Order are countries whose works are treated as those works had they been of Indian origin. Schedule 3 lists the countries which are mentioned in the International Copyright Order. What is excluded from the subject matter requirement is ideas, procedures, methods, systems, processes, concepts, principles or discoveries and devices. Essentially, these are abstract ideas. They are not really expressions of these ideas, which is mentioned as excluded from copyright protection. The second exclusion would involve titles, names, short phrases, slogans, mere listing of ingredients and of contents. All of these would not be afforded copyrightable subject matter. Works that are not fixed in tangible medium would not constitute a fixation requirement within copyright law. So the improvised speech or performance that is not written down or otherwise recorded is not protected. Similarly, works consisting entirely of information that is commonly available and contains no originality, for example, standard calendars, or for that matter, standard measures and rulers, lists or tables which are compiled from the public documents, cannot be given copyright protection. To go on, let's study the basic tenets of what constitutes subject matter within copyright. With that, let's begin with what is literary work. Section 2(o) of the Indian Copyright Act actually does not define this term. It describes computer programs, tables, and compilations, as well as databases within the ambit of what is described as literary work in the provision. Therefore, literary works are not limited to protection or works of literature alone. It includes all works expressed in print or writing other than dramatic or musical works. What is noteworthy is, though, that the protection is not limited to words alone. It includes things such as symbols and numerals, and the scope of the subject matter as the literary work is enhanced by the fact that a work will be protected irrespective of the quality or style of creation in question. Essentially, what it means is that there is no requirement for literary merit for being afforded a copyright protection. All that is required is a standard of originality and that the work originates from the author. It must be fixed in some form in that sense. Almost every kind of written material then constitutes and satisfies and qualifies as literary work. An example would then actually also involve, say, an abridgment. An abridgment essentially is a compressed language of the abridger in comparison to an original text. Therefore, an abridgment connotes to a new book altogether, and so is afforded copyright protection as a literary work, a new one at that. So in the famous case of Macmillan and Company versus Cooper, where the appellant's book had a text consisting of passages selected from North's translation of Plutarch's Life of Alexander, with words being introduced in some places to give it a form of an unbroken narrative, North's translation actually consists of 40,000 words there. However, the text that was finally created by the appellant consisted of only 22,000 words. So the appellant alleged that a similar book published by respondents was an infringement of their copyright. However, the court held that sufficient knowledge, labor, judgment, or literary skill was not expended by the appellant to entitle him the copyright protection. Appellant's work did not amount to an abridgment, which actually should connote to a new work or a new book altogether, and is to be distinguished from just mere abstracts or extracts for that matter. Similar logic would apply to something which is compilation. Like I said, an abridgment is essentially a compressed form of expression, and compilation would be an additive form. However, the Act includes compilation in the very description of literary work. So compilations which are held to be copyrightable are inclusive of, say, a directory, the arrangement of broadcasting programs, a list of registered bills of sale and deeds for arrangement, the bibliographical or biographical notes of prominent golfers published in golf manuals, manuals of classified information for use of motor car insurance, as well as football coupons. So a compilation as such is categorically mentioned as a literary work. That leads us to other questions of whether new editions of books, law reports, judicial decisions, lectures, extempore speech, or even letters constitute copyrightable work within literary works definition.